To welcome everyone to this last meeting for the year with the Windham World Affairs Council. It's my pleasure this evening to introduce Robert Gensburg. Robert Gensburg is a lawyer in St. Johnsbury, Vermont, and he is one of two lawyers in the state of Vermont who has defended pro bono a detainee in Guantanamo. He has quite a bit to say about this, which will probably come out in the question and answer period as much as during the speech. During his presentation, what he's really going to talk about is various times in American history, as in the case of Guantanamo, when security needs have been in conflict or apparent conflict with the liberties of individuals. So that is the nature of his talk. It's essentially historical, and he's going to use several cases to illustrate that conflict. But if you would care in the questions and answers to talk with him specifically about the situation in Guantanamo, I'm sure he'd be pleased to answer your questions. He was very forthcoming at dinner, and I think you'll find him absolutely fascinating. So please welcome Robert Gensburg from St. Johnsbury.
Thank you. As Marco mentioned, I represent one of the 251 now, one of the detainees or prisoners at Guantanamo. I've been actually representing my client since, well, it's been 4 years now, since July of 2005, when I first filed the habeas corpus petition in District Court of Washington, D.C. on his behalf. I'd like to start just by telling you a little bit about my client. It's a little hard to tell how old he is because their calendar is radically different than ours, but he's 36 or 37 years old. He has 3 sons, one of whom he's never seen. His wife was pregnant when he was captured by the United, captured's the wrong word, taken into custody in his home by the United States Army on July 11 of 2002. His wife is still at home. He has a very unwell mother also who lives at home. Afghanistan is an extraordinarily poor, again, by our standards, backward country. I remember hearing one of the military personnel, a general, I forget his name, talking about the progress that they were making in Afghanistan. He said, you know, if we can move this country from the 14th century into the 15th century, we would have accomplished something. And in talking with my client, I understand what the general was saying. It's hard for us to understand, it's hard for me to understand in terms of culture, in terms of history. These people are completely unlike us. They have not had our experience, and we have not had their experience. As I mentioned, he was taken into custody by the United States Army on July 11 of 2002. I have a video of the raid and the capture. He was taken to Bagram Air Force Base, which is a United States prison and Air Force Base about 25 miles north of Kabul. He was held there until October 30 of 2002. He was then flown to Guantanamo, and he's been incarcerated in prison. And you need to understand Guantanamo is a prison. He's been in prison there since October 30 of 2002. I'm not going to say a whole lot about him. I have another point I want to make tonight. But after anybody has any questions about the case specifically, why he's there, what he's charged with, what the government's claims are, my view of the government's claims, because I do have a view of them, I'll be glad to discuss them with you. I would mention that, as I said earlier, there's probably now 247 prisoners at Guantanamo, because 4 either have been or are about to be moved from Guantanamo to Palau in the Marianas Islands. But so far, the District Court in Washington has had, I haven't had one in my case, but has now held 31 habeas corpus hearings for prisoners at Guantanamo. Of those 31, 25, the court determined that the government did not have sufficient basis to hold 25 of them, and that it did have sufficient basis to hold 5 of them. So it'd be 26 and 5 would make the 31 that are there. Let me say these are all habeas corpus cases, and without getting into the details of a habeas case, the threshold of proof that the government has to satisfy in a habeas case is not very high. If there is some basis, some legal basis that will support holding a person in custody, the habeas corpus petition usually is going to be denied. And so far the government, we have a scorecard going, and so far the government has lost 26 of them and has prevailed in 5. Of the 5 in which the government prevailed, they were all decided by the same judge, Judge Leon. The 26 have been decided by several other judges on the bench, the federal court bench, the trial bench in Washington. What I want to talk about is Guantanamo, and put it in the context of what I think, I would say that this is a 4th major national security affair, set of cases that have occurred in my lifetime. And the other 3, the Japanese exclusion cases, the steel mill seizure case, and the Pentagon Papers case that was decided in 1971. The President Bush, and to some degree now President Obama, says that the national security requires that these people be imprisoned, detained is the polite word, at Guantanamo, that these are dangerous people, that if they're let loose, if they're let free, they will cause more havoc on the battlefield. And that as Commander-in-Chief of the United States Armed Forces, and under the authorization for the use of military force that the Congress passed right after September 11 of 2001, the President has the authority as the Chief Executive of the country to hold these people in detention. Many of you probably have read President Obama says some of these people are too dangerous to let free, and yet we can't try them. I think I know the reason why, quote, we can't try them, but nonetheless that's what he says, and that some of them are going to have to be held indefinitely on account of the needs of the national security of the United States. Maybe I should forewarn you, my wife says that she's heard me, I've given this kind of talk in St. Johnsbury once, and she says I'm much too technical and I'm much too dry, and liven it up a little bit. And I told her I didn't know how to liven up and make the subject matter humorous, so please forgive me. So we have a situation where the President of the United States, the national security of the country, requires extra-legal, extraordinary exercise of power by the President to preserve our safety. And as I mentioned earlier, there have been, I think, 3 other cases of this magnitude during my lifetime. I'm not going to tell you I remember the first one because I don't, and that was the Japanese exclusion cases. Although I will say, I remember, I would have been 6 or 7, when the second of those cases was decided, the famous one, Fred Korematsu. When that case was decided, I remember how disturbed and upset my father was by the decision of the Supreme Court in that case that said that the removal of all Japanese citizens from the West Coast and their relocation in central United States, Nebraska and Kansas, where they had the camps. I just remember that my father was upset about it, and I really didn't understand why. That's my only recollection. The rest of it is all intellectual from reading the cases. The second was a steel mill seizure case. I do remember that quite well. And the third one was the Pentagon Papers case. And by then I was a lawyer. And I remember that one because I followed it so carefully, extremely well. So let's start with the Japanese exclusion cases. Right immediately after Pearl Harbor, President Roosevelt declared the west coast of the United States a military zone, and the Congress gave President Roosevelt the authority, substantial authority, because he was the president and he's commander-in-chief of the armed forces, to control all kinds of life that was going on the west coast. They created a military district, which made up California, Oregon, Washington, some of Arizona, and General George DeWitt was appointed the commanding general of the military district. And DeWitt, after about 7 months or 8 months, promulgated an order essentially imposing a curfew, not essentially, imposing a curfew on all people on the West Coast of Japanese descent, whether they were citizens or whether they were not citizens. They were not allowed to be anywhere other than in their homes between 8 o'clock in the evening and 6 o'clock the following morning. A law student at the University of Washington, Gordon Hirabayashi, thought that that was unconstitutional, and he stayed in the law library studying after 8 o'clock. He was arrested, was charged with violating the curfew, and was convicted and sentenced to serve 3 months in jail. The Hirabayashi case is not as famous as the Korematsu case, but in some respects it's more important because of what happened 20 years later, which I will discuss. So, about 4 months after the curfew order came down, DeWitt issued another military order requiring all Japanese people of Japanese descent, citizens and non-citizens, to gather at basically relocation areas to be shipped out of the West Coast to these camps that had been set up in Washington, in Nebraska, Kansas, and Oklahoma. Both Hirabayashi was out, he'd served his sentence, and so he was out, and a man named Fred Korematsu refused to obey the order. The reason they refused to obey the order was because they claimed it was based on race prejudice. The government said, no, it's not based on race prejudice. There was a serious danger that these people are disloyal. We can't tell which of them is loyal and which of them is not loyal. But some of these people are disloyal and likely to commit espionage, likely to promote the interests of the Japanese military effort, both in Hawaii and on the West Coast, and therefore they should be removed from the West Coast so that they cannot commit these awful acts. So Fred Korematsu and Gordon Hirabayashi, there were some others, refused to report to the relocation center. They were arrested, they were charged, they were convicted. They appealed their cases to the Supreme Court, and they lost. Both Korematsu and Hirabayashi lost their cases. Now, it's important to keep in mind what the government's justification for this removal from the area was. It was that these people, some of these people, we don't know who, but some of these people were spies or would commit sabotage or otherwise would impede the war effort. And one of the great libertarian or liberal justices of all time, Hugo Black, wrote the majority opinion. There was a dissent. He wrote the majority opinion in the Korematsu case. And in his majority opinion, he says, and I quote, "Nothing short of apprehension by the proper military authorities of the gravest imminent danger to the public safety can constitutionally justify the curfew for the exclusion order. And then went on to say that the military authorities had that proper apprehension, and therefore it was constitutional for them to require these people to move for the duration of the war into the central United States. The court at that time, there was some really fine justices on the court. Another one, maybe my favorite of all time, was Robert Jackson. Jackson was FDR's Attorney General. He was the chief prosecutor of the Nuremberg trials for the Allied forces, and he was the justice on the Supreme Court. And he made this point in the Korematsu case, and I'm reading again. A citizen's presence in the locality, however, was made a crime only if his parents were of Japanese birth. Had Korematsu been one of four, the others being, say, a German alien enemy, an Italian alien enemy, and a citizen of American-born ancestors convicted of treason but out on parole, only Korematsu's presence would have violated the order. So what happened in the Korematsu and Hirabayashi cases is that they were decided, and that became the law because it was a decision of the United States Supreme Court, until about 1980 or 1981, when both Hirabayashi and a woman, Itsui Endo, and Fred Korematsu brought new cases in the district court where they were convicted of violating the curfew order and the relocation order because they had done some research in the National Archives, and what they had found in the National Archives seemed to indicate that General DeWitt really didn't think that there was an imminent danger of an attack from the Japanese, or that these people were going to commit sabotage, but rather it was motivated by race prejudice. So the Korematsu case that was brought again in the 1980s didn't go anywhere. But Hirabayashi's did, because he brought his case later than Fred Korematsu, and they had, in the National Archive, found some rather damning memoranda that had been written by General DeWitt about why these people were going to be relocated. And I won't go into the words he used, and I won't go into the reasons he gave, except to say that it's because he didn't like Japanese people. And number two, he really didn't think there was any imminent danger that Justice Black wrote about. Nothing short of apprehension by proper military authorities of the gravest imminent danger to the public safety really existed. When they dug into the case even further, what they found was that DeWitt had written a memorandum for use in the trial of Hirabayashi that never mentioned anything about the danger that he might, or anybody else might, pose. The Solicitor General of the United States said, when he found that, when the case was on appeal to the Supreme Court, the Solicitor General of the United States decided that that was not going to be sufficient to persuade the Supreme Court to uphold the conviction that had occurred in the district court, so they got DeWitt to change his memorandum to put he wrote a second memorandum. This is the Solicitor General of the United States, to change his memorandum to make it stronger, to make the national security issue stronger and the racial aspect of it weaker. And sure enough, in the Ninth Circuit Court of Appeals, which is the Federal Court of Appeals that sits in San Francisco, decided in 1987, reading from Judge Schroeder's not majority opinion, this was a unanimous opinion of the court. She starts out by saying, The Hirabayashi and Korematsu decisions have never occupied an honored place in our history. They demonstrate, these memos that I've mentioned, demonstrate that there could have been no reasonable military assessment of an emergency at that time, that the orders were based upon racial stereotypes, and that the orders caused needless suffering and shame for thousands of American citizens. So the moral, the message being so much for national security being an important issue in the Japanese exclusion cases. The next case I want to talk about, and I do remember it, is the steel mill seizure case. The Korean War was coming towards its end, but steel obviously was a very important component of the war effort. And at the same time, the United States was in the process of rearming the NATO countries, and that also required ready availability of steel. The United Steelworkers was going to go on strike. So President Truman, as I mentioned at dinner, I'm not going to be too harsh about President Truman. He's one of my favorite people of all time. I really think the world of him. But in this particular case, he was on the wrong side. So President Truman ordered his Secretary of Commerce, Fred Sawyer, to seize all the steel mills and operate them so that the war materiel would continue to be produced. And his very close friend, Hugo Black, because they were senators together in the 30s, his very close friend wrote the majority opinion in the steel mill seizure case. And this is how Justice Black described the government's position. The government's position is that the order to seize the steel mills was made on findings of the president that his action was necessary to avert a national catastrophe, which would inevitably result from a stoppage of steel production, and that in meeting this grave emergency, the president was acting within the aggregate of his constitutional powers as the nation's chief executive and commander-in-chief of the armed forces of the United States. Now, I would suggest to you that that formulation is not a whole lot different than the justification that's been given for keeping these people in Guantanamo, or for that matter, excluding all the Japanese American citizens from the West Coast during World War II. The steel mills, this is probably interesting only for a lawyer, but the steel mill seizure case is really important because Justice Jackson wrote a concurring opinion in it, and it is an absolutely magnificent concurring opinion about the authority and the power of the executive and of the legislature and of the judicial branch of government. And I'm not going to bore you reading from it, but once a year I go back and I read that concurring opinion. It is just so well done, and it's important to keep those principles in mind. Well, the Supreme Court said, 6-3, that the president did not have the power to seize the steel mills. There were two reasons for that. Number one, he doesn't have inherent executive authority to seize private property for any reason. And the other thing is that the Congress in 1948 had passed the Taft-Hartley Act. The Taft-Hartley Act was made serious inroads into the power of the labor movement. And Harry Truman hated the Taft-Hartley Act. But it would have given him the authority under different kinds of circumstances, but nevertheless, it did give him the authority to actually keep the steel mills running. But he wasn't going to give his truly hated Senator Taft the pleasure of relying on the Taft-Hartley Act to bring the steel mill strike to an end. So he did it on his own motion. So they did strike. They were out on strike for 52 days. And the steel mills really were shut down for 52 days. the information shows, the data show, that the war effort was not impeded, the Korean War effort was not impeded in any way by the strike. And it shows that we were able to continue to rearm NATO countries in Europe. It was still devastated from World War II, even though the steel mills had been shut down for 52 years. All of which, 52 days, all of which is to say the national emergency that the president said necessitated his seizure of the steel mills, in fact, did not exist. It just wasn't there. The third case is the Pentagon Papers case, and everybody, or most everybody, is going to remember that in 1971. The Vietnam War was dragging on, dragging on, dragging on. And Daniel Ellsberg, he's a worker for a contractor who was working in the Pentagon, was aware that the Pentagon had assembled a large volume, there are 52 volumes of material altogether, a large volume of their analysis, the inside analysis about how the war was going. And that analysis was at odds with what the president and the generals and the Defense Department were telling the country was actually going on. So Robert McNamara was telling us one thing when in fact he has been saying inside the Pentagon that something else was what was true. So Ellsberg leaked the Pentagon Papers, or some of them, to the New York Times. So the New York Times is sitting on these dynamite, political dynamite. They called the Attorney General, at the time I think it was John Mitchell, called the Attorney General and said, we got these papers and we're thinking about publishing them and we want you to know. So they let him know ahead of time. Well, that created a firestorm in the Nixon administration, and there was a lot of back and forth and back and forth and back and forth about whether they were going to publish the papers or not. And the Times thought about it hard and long before it went ahead and did that, but then it did publish the first set of the Pentagon Papers. And I remember what had happened. I remember reading it and being surprised that this stuff had become public. So the United States went to court and obtained an injunction against the New York Times while the district judge is in New York City, while the district judge considered whether or not to issue a permanent injunction against the publication of the Pentagon Papers. So the next day, the Washington Post published installment number 2, because they had them too. And by then it was fairly clear that nobody was going to prevent the publication of the papers. But in any event, the judge, the New York Times and the Washington Post later immediately appealed the injunction to the United States Supreme Court, because there's an important Supreme Court case called Neer versus Minnesota, and it says that there can be no prior restraint. It holds that there can be no prior restraint on the publication of information in the press. And an injunction, that's exactly what it is. It was a prior restraint on the publication of any additional parts of the Pentagon Papers. So the case went to the Supreme Court, and how the case was handled there is very interesting. I don't remember the exact days, but I do remember the timing. Assume the petition, it's called a petition for writ of certiorari, is filed in the Supreme Court by the New York Times on Wednesday. The injunction comes down on Tuesday. File the appeal to the Supreme Court on Wednesday. On Thursday, the Supreme Court ordered all parties to brief the case and exchange briefs Friday morning, and they're going to have oral argument beginning at 10 o'clock on Friday morning in the Supreme Court, when the injunctions just come out on Tuesday. That's important. The timing is important because the Solicitor General of the United States at the time was an extraordinary lawyer. His name was Erwin Griswold. And here he was on Wednesday afternoon, faced with the task of briefing this case, not having seen the other side's brief, and arguing it for the United States a day and a half later. Now, the government's case consisted of two pieces. There was the public piece, and there was a private piece. And the private piece was a compilation by the Defense Department of all the bad things that were going to happen if these papers continued to be published. So what Griswold did was he assigned the writing of the public part of the brief to one of his deputies, and he undertook to write the secret brief that was going to be given to the Supreme Court. And that's what he did. Now, this is a brief, it is a secret brief. The other side, the lawyer for the New York Times, for the Washington Post, never saw it. It's filed with the court under seal, and the court heard the argument on Friday. Actually, I can tell you what day it was. June 30, 1971 was the day it was argued and the briefs were exchanged. Very late in the afternoon. And the Supreme Court, it's an interesting split in the decision, but the Supreme Court broke into three separate parts. Three of the justices, Justice Black, Justice Douglas, Justice Brennan, not surprisingly said, there can never be an injunction against publication in the press, period. Three of the justices, Justice Stewart, Justice White, White, Thurgood Marshall, they said, well, I don't know if I want to go that far. There might be a case where a prior restraint would be appropriate, but this is not that case. So now you have six justices ready to rule that the injunction should not have been issued. And three of the justices dissented and said, you can't have a prior restraint, Neer versus Minnesota notwithstanding, and this is one of those cases. And that was Chief Justice Berger, Justice John Marshall Holland, really a fine justice, and Justice Blackmun. Now, I want to read, it's only a paragraph, don't worry. I want to read to you from Justice Blackmun's dissent in the Pentagon Papers case. The judge who tried the case, the district court judge, was a Judge Wilkie. And he said, Judge Wilkie, after a review of only the affidavits before his court, the basic papers had not then been made available by either party, concluded that there were a number of examples of documents that, if in the possession of the Post and the Times, and if published, quote, could clearly result in great harm to the nation. Remember those words. Could clearly result in great harm to the nation. And he defined harm to mean the death of soldiers, the destruction of alliances, the greatly increased difficulty in negotiation with our enemies, the inability of our diplomats to negotiate. I, for one, have now been able to give at least some cursory study, not only to the affidavits, but to the material itself. I regret to say from this examination, I fear that Judge Wilkie's statements have possible foundation. I therefore share his concern. I hope that damage has not already been done. If, however, damage has been done, and if with the court's action today, these newspapers proceed to publish the critical documents and the results therefrom, the death of soldiers, the destruction of alliances, the greatly increased difficulty of negotiation with our enemies, the inability of our diplomats to negotiate, To which list I might add the factors of prolongation of the war and a further delay in freeing of the United States prisoners, then the nation's people will know where the responsibility for these sad consequences rests. Now we'll fast forward to 1989. Irwin Griswold, the man who wrote The Secret Brief and who argued the case for the United States in the Pentagon Papers case, in 1989 wrote an op-ed piece for the Washington Post. The title of the op-ed piece is "Secrets Not Worth Keeping." I won't read the whole thing to you. He talks about how he was up all night writing the secret brief, how the Pentagon gave him 40 secrets that they wanted him to tell the Supreme Court. He rejected 29 of them, but he kept 11. And then he says, so I went ahead and presented the case before the court, relying only on the 11 items. As is well known, we lost by a 6-3 vote, with 3 members of the majority saying there could never be a prior restraint, while 3 others said that a prior restraint would be appropriate in the proper case, but that there was no adequate threat to national security in this case. Accordingly, the newspapers printed many items from the Pentagon Papers. Now this is the lawyer who argued the case and wrote the brief for the United States. I have never seen any trace of a threat to the national security from the publication. Indeed, I have never even seen it suggested that there was such an actual threat. It quickly becomes apparent to any person who has considerable experience with classified material that there is massive overclassification and that the principal concern of the classifiers is not with national security, but with governmental embarrassment of one sort or another. I can't stress it enough. This is the same lawyer who argued the case for the United States in 1971. Then he goes on to say that there was never any real risk to current national security from publication of facts relating to transactions in the past, even the fairly recent past. This is the lesson of the Pentagon Papers experience, and it may be relevant now. And I think we haven't learned the lesson yet. Now, as you probably know, the United States Supreme Court's had 5 Guantanamo cases before it. 2 of them involved the question of habeas corpus, whether non-citizens of the United States held in the prison at Guantanamo are entitled to the privilege, that's the word the Constitution uses, the privilege of habeas corpus in the United States Supreme Court, in the United States courts. Habeas corpus means you have the body, you have to explain why you're holding it. In a habeas case, what happens is petitioner files a habeas petition, the government files what's called a factual return. The factual return says, we are holding this prisoner because 1, 2, 3, 4. And the reasons for his detention, been convicted of a crime or whatever, are given in the factual return. Then the petitioner files what's called a traverse. No, this isn't true. No, this isn't true. No, this isn't true. And then you have, it's like a lawsuit. You have the plaintiff's complaint, you have the defendant's answer, and then the judge makes a decision. So there were 2 of the cases. The first one was the Rasul case, Shafiq Rasul, that was decided in 2004. And in that case, the United States Supreme Court held 5-4 that the prisoners at Guantanamo did have a right to bring a habeas corpus petition under the habeas corpus statute that's been on the books ever since the first Congress met in 1787. So the Congress immediately passed the Detainee Treatment Act of 2005, which attempted to strip the Supreme Court of, and any lower court, of jurisdiction to hear habeas corpus cases brought on behalf of detainees who were being held in Guantanamo who are non-American citizens. And so now you have the question, well, if you couldn't bring a habeas case under the statute, the Constitution still says that the privilege of the writ of habeas corpus shall not be suspended except in times of invasion and rebellion. So the question then becomes, does that constitutional prohibition against suspension of the writ apply to the people who are at Guantanamo, and it was June 24, a year ago, the Supreme Court said in the Boumediene case, said yes, that the Constitution of the United States prohibits the United States from preventing the Congress preventing these people from bringing habeas petitions in the United States court. And that's because Guantanamo is essentially American territory, run by the United States Navy. Cuban law doesn't apply there, only United States law. Cuban law, under the treaty that we have with Cuba, Cuban law simply doesn't apply there. There's no Cuban law at Guantanamo, it's only United States law. Cuba retains residual sovereignty in the event the United States, the lease is perpetual. So if the United States decides it doesn't want to be at Guantanamo anymore, then Cuban sovereignty would come into play. But the reason I'm going into that with Boumediene, because I want to read from Justice Scalia's dissent in the Boumediene case. And as I do that, please have in mind Justice Blackmun's dissent in Pentagon Papers case. And Justice Scalia writes, I think it appropriate to begin with a description of the disastrous consequences of what the court has done today. The game of bait and switch that today's opinion plays upon the nation's commander-in-chief will make the war harder on us. It will almost certainly cause more Americans to be killed. In the short term, the decision is devastating. And then he goes on to describe how some of the people who were being held in Guantanamo have been released and returned to the battlefield. And he cites a report from a minority report from the United States Senate about all these people have returned to the battlefield, when in fact, Seton Hall University had done a study of the Defense Department's claims about people who were released from Guantanamo and had returned to the battlefield and completely debunked it. Now, you may remember just in the newspapers just recently, maybe within a month, 6 weeks or so, the Defense Department put out some information that 1 in 7 of the people who have been released from Guantanamo have returned to the battlefield. Well, it actually comes out to something like 2 out of 68 of the people that the Defense Department was talking about, they can say, with some reasonable degree of certainty, did in fact return to the battlefield. And the other ones, it's all suspected, it's all based on hearsay. In some cases, returning to the battlefield means that one of the people who were released and went home to Britain, which was his home, gave a very scathing editorial, a scathing interview to a newspaper in England that got published. He returned to the battlefield. But that's one of the, and it goes on and on and on like that. So, the moral of the story is that since 1945, we've had 3 major sets of cases that in which the president exercised extraordinary authority on the grounds that the national security required it. And as you can tell from what I read about the Japanese seclusion cases and what happened with the Steelman seizure case and the Pentagon Papers case and what Irwin Griswold, not me, had to say about the consequences of those papers being published is all bogus. When we consider that the same reasons are being given to hold these prisoners at Guantanamo, we should at least have in mind our history with these kinds of cases and question, I don't even question it anymore, but because I'm more familiar with it than most people, but we should, at a minimum, question the validity of the claims that the government makes. So every time I give one of these talks, I end with I read from a sentencing comments that District Judge John Pofenauer in Seattle gave in 2005 when he sentenced Ahmed Ressam to 22 years in prison. Ressam was a Millennium Bomber. He was a guy who came down from Canada, was caught at the border. He had a car full of explosives, and he was going to LAX, and he was going to blow up LAX on New Year's Eve. So he got sentenced, and at the end of the sentencing comments, this is what Pofenauer had to say. Now keep in mind that this is a judge who actually has the experience of trying one of these terrorist cases. He's done it. He's been through it. And he said, the message I would hope to convey in today's sentencing is twofold. First, that we have the resolve in this country to deal with the subject of terrorism, and people who engage in it should be prepared to sacrifice a major portion of their life in confinement. Secondly, though, I would like to convey the message that our system works. We did not need to use a secret military tribunal, or detain the defendant definitely as an enemy combatant, or deny him the right to counsel, or invoke any proceedings beyond those guaranteed by or contrary to the United States Constitution. I would suggest that the message to the world from today's sentencing is our courts have not abandoned our commitment to the ideals that set our nation apart. We can deal with the threats to our national security without denying the accused fundamental constitutional protections. Despite the fact that Mr. Ressam is not an American citizen, and despite the fact that he entered this country intent upon killing American citizens, he received an effective, vigorous defense and the opportunity to have his guilt or innocence determined by a jury of 12 ordinary citizens. Most importantly, all of this occurred in the sunlight of a public trial. There were no secret proceedings, no indefinite detention, no denial of counsel. The tragedy of September 11th shook our sense of security and made us realize that we, too, are vulnerable to acts of terrorism. Unfortunately, some believe that this threat renders our Constitution obsolete. This is a Constitution for which men and women have died and continue to die, and which has made us a model among nations. If that view is allowed to prevail, the terrorists will have won. Thank you. Try to answer any questions unrelated to, related to or unrelated to what I was talking about. Yes, sir.
Can we close Gitmo? Can we?
There's absolutely no question in my mind whatsoever that the prison at Guantanamo and what goes on there can be closed. First of all, we need to keep in mind what's wrong with Guantanamo is not its physical location. What's wrong with Guantanamo is what takes place there. And what takes place there can take place anywhere. The administration understood that it probably could not take place very long. It was conducted in the United States, and so they selected Guantanamo because they believed incorrectly that it was not a part of the United States, which it is. People, we have true, dangerous people locked up in prisons throughout the United States. And I've seen only one of them. Nobody's getting out of any of those prisons. The reason why it's important to keep in mind that out of 31 habeas corpus cases, the government has lost 26 of them. In a case where the threshold for detaining them is not that high, should tell you something about the danger of some of the people who are being held at Guantanamo. So you've all read about the Uyghurs and who, by the way, have been ordered released and are still in Camp 4 at Guantanamo, with the exception of 4 of them, because the United States won't bring them to here, and nobody else wants to take them. We're not going to take them. So, but the answer, in my opinion, is we can have trials. It's what Judge Kuffenauer said. We can try these people. We're doing it right now with the Rajani. He was the he was a participant in the bombing of the embassy in Kenya, and he's in New York, and he's going to be tried in the United States District Court in New York in a criminal case with a lawyer and all of those other things. And there's no reason why that can't occur. Yes, sir.
First of all, I want to thank you for a fascinating and depressing talk. I have 3 small questions, or 3 points regarding the Japanese situation on the West Coast. One, a minor question, is were the ethnically Japanese in Hawaii also involved, or was it just California, Washington, and Oregon? And my second...
We're in Hawaii as well.
Uh-huh.
Yes.
The second point is, did the Japanese ever raise the issue in their lawsuits or in any other way about the fact that there were a bunch of Germans, for instance, a German colony in New York City, Yorkville, where the storefronts and even the street signs, the parking signs, were all in German? Now, were those people, first of all, ever in danger of being put into these detention centers? And second of all, they weren't. Second of all, did the Japanese ever raise that as an issue?
They did. And I read that little excerpt from Justice Jackson's dissent in Korematsu, where he said, the German enemy alien, he's not subject to any detention or etc. But let me go a step further. There's another case coming out of World War II. It's called Ex parte Quirin. It's another habeas case, but I won't get into the legal part of it. But in Quirin, a German submarine landed 4 German saboteurs on Long Island and 3 German saboteurs in South Carolina, and an German-American citizen joined them, and they were going to Chicago, and they were going to commit some kind of sabotage. So there was a concrete example. Before this all happened, before the Korematsu case was decided, there was a concrete example of German enemy aliens not being subjected to the same exclusion order that the Japanese were.
And the third point was one that I'm not too aware of the exact outcome, but we happen to know a Japanese woman who was born in one of these detention centers. And some years ago, she was given compensation. So there's a slightly happy ending, apparently. Congress voted some funds to compensate the survivors and their descendants.
Yeah, that happened. I'm aware of that. That happened in the late 80s, but I'm not exactly sure when. But it was around the time that Hirabayashi case was decided in 1987, because what had happened in that second round in Hirabayashi was that all of these memos, all of the Defense Department, War Department, it was the War Department at the time, all these memos, including memos that had been written by George DeWitt, had become public because they had been found in the National Archive. And what had always been regarded as one of the worst times of American jurisprudence was proven to be that. And yes, the Congress did appropriate money to compensate some of the victims. Yes?
The first 3 cases is that a lot of your condemnation of them were fact-based, that in fact the Japanese internment case was racially based, and in fact the Pentagon Papers didn't cause any problems, and in fact we were able to carry on with our wonderful wars with the steel plants closed. But if your argument is, and I know your argument is more than this, but if your argument is fact-based, then a response would be, well, Bush and now Obama can say, well, yeah, those cases were decided wrong, but I know best, and I'm telling the truth this time, and we really are, even though we weren't then, we really are in danger. And so how do you respond? How do you respond to that? And I think that reading that one case of the in Seattle case sort of answers that. But I mean, there's got to be more than just. I mean, even if Obama and Bush were right, that boy, this would really be dangerous if we followed the Constitution. How do you respond to that?
Well, we started following the Constitution after the Boumediene case was decided just a year ago. And we've had all these habeas corpus, we've had trials. And some of them have been found properly detained, and some of them, most of them at the moment, I don't want to mislead, I don't think that this ratio is going to hold. And I think as time goes on, more and more of these people will be found eligible, if that's the right word, to be detained. But the point is what Kofenauer said, it's not whether the president is right or whether the president is wrong. We have a set of principles that we follow to make that determination. George Bush decided that he wasn't going to follow those principles to make that determination. That because he was a commander-in-chief of the armed forces, he had extra legal authority to hold these people. He doesn't. And if you have somebody who's truly dangerous, like this man who's going to be tried, or like Ahmed Ressan in Seattle, you try him. You have a fair hearing. If I told you what the hearings are like in these Guantanamo cases, your hair would fall out. It wouldn't just stand on end. Let me tell you what a combatant status review tribunal is. That's a formal proceeding that was created by the Defense Department. The petitioner is not allowed to have a lawyer. He has somebody called a personal. Keep in mind, they don't speak English. Almost nobody there speaks his language. He's allowed to have what's called a personal representative. The personal representative is an Army officer. Now, my client's shackled, he's in his jumpsuit, he's in his cell, and whenever he meets with his personal representative, the personal representative is dressed in uniform, and the first thing he tells him is, anything you tell me, I'm going to tell the tribunal. He's required by the rules to tell the prisoner that you can't confide in me, and if you do, I'm going to tell the tribunal what you tell me, and he's required by the rules to tell the tribunal. So that's the kind of hearings that up until 2008 that have been available for these people. Nothing I'm saying here is classified. This stuff is well known. But the point I'm trying to make is not that these prisoners at Guantanamo should be let free. The point I'm trying to make is that we've been told 3 times now in important cases that the national security required this extraordinary behavior by the president, and we were wrong 3 times. You know, fool me once, shame on you. Fool me twice, shame on me. This is the 4th time around. We should question the good faith, the bona fides of the president when he says we may have to hold some of these people indefinitely. This is an important part of it, but it's not an answer to your question. You should also ask yourself, if you have a guy who really, really is dangerous and you can't try him, why can't you try him? What happened that will prevent a fair trial? Then you know the answer. The information they have was obtained by torture. That's why they can't try him. Well, how reliable? How can you conclude that this man is really, really dangerous if the evidence you have is totally unreliable to lead to that conclusion? So I wasn't saying all these people should be let loose. What I'm saying is that we were lied to 3 times, and in substantial respects, based on what I know from what I've learned in this case, we're being lied to again. Yes?
There's no distinction, is there, between the rights of an alien and the rights of a citizen a criminal trial in the United States?
Yes, distinctions most certainly can be made. Depends where the crime was committed. So if it was committed outside of the United States, for example, the United States does have jurisdiction to, well, technically speaking, an embassy is United States territory. But the bombing in Kenya did take place outside the United States.
That's different. First of all, I'm not sure that's right. You have,
Could you speak a little louder?
I'm sorry, you have clearly the right to try piracy in the courts of the United States about the crime, and he's not a citizen, and the crime is committed outside the United States.
Yes.
So, and some of these other cases, like the embassy in Kenya, but the Fourth, Fifth, and Sixth Amendments, which deal with criminal trials, do not make any distinctions between a citizen and a non-citizen being tried in the courts of the United States.
Okay. They do not. And we'll go a step further. We're looking at it on the state level, and we talk about the due process clause in the Equal Protection Clause in the 14th Amendment.
Equal protection is
Right.
different.
And that what they say is that no person shall be deprived of his life, liberty, or property without due process of law. No person shall be deprived of his of the equal protection of the laws. And in the same 14th Amendment, it says that any person born in the United States and naturalized therein is a citizen of the United States and a citizen of the state within which he resides. So when the people drafted the 14th Amendment, they very much had in mind the difference between a citizen and a person, and they used the word person when they described the all-important due process right and right to equal protection. Yes?
How does the so-called regular legal system or trial system accommodate issues such as not speaking English, cultural differences, and in order to provide a, quote, fair trial, as opposed to a military tribunal, et cetera, et cetera. In other words, I'm trying to understand why we would want to advocate for the use of our, quote, regular system, especially if we sort of go under the feeling that a fair trial requires a jury of your peers, because they're not going to be cultural peers. They're going to be biased peers, if you will, in italics or quotation. And it's sort of a philosophical, conceptual question I'm asking, and I'm not quite sure how to phrase it very well.
No, I think it did. And as you were asking the question, I was thinking of an answer, and I said to myself, it's a philosophical answer, and I'll have to say that. We'll take the easier part first. If I'm going to have a trial for my client with a jury, it's up to me to overcome those cultural, figure out how I'm going to do it. We do this, lawyers do this all the time. Figure out how I'm going to overcome those cultural differences. He doesn't speak English, so I'm going to have a pass-through English interpreter at the trial. But my preparation of my client on how to behave and how to explain his case, it's up to me as his lawyer, as his advocate, and those are handicaps, but it's up to me to overcome those handicaps. And I think I can do that. Okay. The philosophical part is that we've developed this fair, and it is fair, we have developed this fair way of seeking the truth in a criminal context. Done it in this country for 200 years. precedes us in England for a long time before that. Whenever you start to tinker with or deviate from those principles, first, you're really deviating from the rule of law. Second, these methods, these techniques have evolved through tremendous quantity of experience, and they work. And I would say I have I really do. I have every confidence that a fair trial can be had, fair to the government, fair to these people, trial can be had for these people who are being held in that trial. I'm going to tell you what I am going to follow up. I was involved in a major regulated drug case in St. Albans in 1973 to 1975. We had a policeman running around who was taking phony buys from people on the street. And 106 people were convicted of selling regulated drugs that they never sold in. Right around that same time, I remember Watergate was unfolding before us. And it always struck me that the Nixon administration, one of their prime selling points for votes was law and order. Law and order. And I was asked to give a talk I was asked to give the Justice Jackson lecture at the law school that I attended in 1974, 1975. And I remember that picture of John Mitchell standing on the balcony of the Justice Department looking out at crowds being arrested because they were peaceably assembling for the redress of grievances against the government. And Agnew, Haldeman, Ehrlichman, Mitchell, all ended up in jail. And when I was giving this talk about this drug case at the law school, it just came to me at the time. I said, just follow the law, the order will take care of itself. If we just follow all these procedures that we've developed over the years, the trials will be fair trials. And sometimes we come up with the wrong answer. Most of the time we'll come up with the right answer. Yes, sir.
So, based on that, I have a question which is very interesting. You mentioned about your client and how he was picked up. There's an interesting story, a fact about a man called Masood, who was arrested on the Pakistan-Afghan border after the fall of Afghanistan. He was among the original 720 or so get-go detainees. In 2005, he was released. He was among the first 20 or 30 or 50 who were released. He promptly went back to Pakistan, raised 10,000 tribesmen who are today, at this very moment, fighting the Pakistanis. He was killed, deliberately targeted by the US and the Pakistanis and killed, but replaced by other people. He stated the reason why I have risen up against the US. I'm totally innocent. I never fought the United States. I never participated with the Taliban. But because I've been tortured in the way I've been treated at Guantanamo, I will now take my revenge. Now the question I have is this: under what circumstances, under what hearings was he released? He was just let go. Do you know of these cases, the early cases?
We don't know why those people were released. We probably never will know. What you recited is something that's bothered me. I mean, you could take somebody who's perfectly innocent and honest, and after going through that experience, all of a sudden he's not going to like us anymore. I don't know the extent to which that's true or that's happened. But we don't know why it was a Defense Department decision, not a Justice Department decision, why those people have been released from time to time. Whether maybe they were going to be moles or spies, and could be any number of reasons. We don't know, and we probably never will know. But it's clear that some bad decisions were made. Yes?
It was my belief that when Obama became president, he had made the statement that he would close Guantanamo.
Yes.
Recently, he seems to be equivocating or somehow putting off to one side that decision. Do you know why and what's behind all of this?
First of all, he's got great difficulty in the Congress with the idea of closing Guantanamo. Now, this is speculation on my part. He's got a whole bunch of other things that he wants to get through the Congress. And this may very well be a fight that he doesn't want to fight at this particular time, because they're working on a health care bill right now, and he's made health care probably the signal effort that he wants his administration to accomplish. He's got the energy bill with the cap and tap in it, and that's creating great controversy in the Congress. You have a public that's been inflamed about these prisoners at Guantanamo, and I'm guessing, but I think he just may not want to take up that fight right now. I had this long discussion with my son, who voted for McCain, I'm embarrassed to admit. But Obama did something contrary to what I'm working on with my client. I don't even remember what it is, but what he said was, why did he do that? And he said something, and I said to him, watch what he does, don't watch what he says. And because I'm so close, like nobody else in this room, I'm so close to everything that goes on every single day. There are other things we don't see about Guantanamo that don't make the papers, that's what I should say. There are other things going on there. It's become much more difficult since he's become president for me to work on behalf of my client. It just made it harder, not easier. But I see some other things that are happening that make me think in the end he's going to try to do the right thing. That's the best answer I can give you.
But for domestic reasons, yet it was going to be the international litmus test that the rest of the world know that America's getting.
He also gave himself till next January to do it. He says he's going to close it within a year. This is June, so I have my doubts. I'm not apologizing for the president. What really turned me off was when Eric Holder went to Guantanamo and came back and made a public statement that we're treating the people there humanely. My client has been in solitary confinement for 3 years.
Oh.
He gets out of this cell for an hour and a half between the hours of 12 and 1:30 every night, all by himself in the car to get exercise. And the rest of the time, since March 30 of 2006, he's been in solitary confinement. And Mr. Holder knows that. Yes?
My question is whether he is allowed to have any kind of communication with his family or with government representatives.
Under Red Cross rules, he's allowed to write to his family, and his family is allowed to write to him. He's very literate. He's a highly, that's how he got in trouble. He's a very, very acutely intelligent man. He became absolutely fluent in Arabic in high school in 4 years. That was his introduction to it, and he speaks Arabic fluently today. So they're allowed to write. Nobody in his family can write. He's allowed one phone call a year. He can talk to his family on the phone once a year. That's about it. The only other communication he has with the outside world is with me. Yes?
We often hear our government's claims about why they don't want open trials because of intelligence matters. And perhaps one example could be, let's say a predator drone saw an individual planning an IED, and if that went to open trial, it seems like the government's claim is that would then have to disclose some of those particular intelligence type systems that we have in place. What are your thoughts on the government's claims? Do you think it's a smokescreen, or do you think there's some
No, I think it's a
real
problem,
basis?
and Judge Kofenauer dealt with that problem because he had some secret stuff. He dealt with that problem, I don't know how, but he dealt with that problem of secret information in his trial. I'm trying to remember the name of the Egyptian sheik who masterminded the first attempt to blow up the World Trade Center. I can't remember his name. But there was all kinds of secret stuff in there. You know, among other things, I know what they do. The lawyer, I have a security clearance. I had to get a security clearance just to represent Zahir in this case. But I get a security clearance. If it's really sensitive stuff, I'll get a top secret clearance. And then we'll go into chambers, and the government will be there, and I'll be there on behalf of my client. And the judge will be there, and we'll discuss all the secret information. And then the judge will tell me what I can tell my client about what we've been discussing, so that he can say that never happened, or yes, I did that, or respond to it in some way. It can be dealt with. And the trial judges, I have a list here of 65 terrorism cases that have been tried in the United States District Court, here in the United States. Trials with judges and juries, and not one of them resulted in an acquittal. And they were chock full of all kinds of secret information.
And in the official record, then, are those secrets actually withheld from the written record
They are.
for public review?
They're sealed.
They're sealed.
They're on file in the court, but they're sealed. It
So
can be handled.
it sounds like it is a smokescreen on the government's part, then. That they're-
Yes?
Yeah, I remember hearing that Roosevelt especially was very hesitant and resisted doing what was ultimately done, and it was political pressure. And when I think about it, I think it's a pretty good constituency in the country that where we would be deeply offended if our own rights were taken away. If we're frightened and afraid and scared, we think there's nothing wrong with, taking other people's rights away to protect ourselves. In other words, there wasn't a big constituency rose up and said, don't do this or we'll vote against you.
That's right. And that's what judges are for. So that when the president and the Congress act in an extra legal way, the courts, and they have not, with the exception of the U.S. Supreme Court, the courts have been sorely remiss in dealing with the abuse that these people have absorbed ever since they were first captured. Yes?
A very minor point with respect to the worry that the administration or the Pentagon had with respect to the released Guantanamo detainees going back to war against the U.S. When I was in the Marine Corps, as part of our training, we were instructed if we were in fact captured by the enemy, it was our duty to escape or try to escape and to rejoin our outfit. So it was expected of us, and so I suspect that they're fully aware of this whole issue.
Yeah, there's a question about that, and having to do with the Geneva Conventions. And the Third Geneva Convention deals with prisoners of war, and among other things, prisoners of war are, under the convention, are allowed to try to escape. There's a specific provision that that's not a war crime for a prisoner of war. But these people are not prisoners of war, so they fall under the Fourth Geneva Convention. There are 4 Geneva Conventions. The first one deals with medical personnel. The second one was shipwreck soldiers and sailors and now airmen. Third one, prisoners of war. The fourth one is everybody else. Anybody else who falls into enemy hands at any time, civilians, are subject to the Fourth Geneva Convention. And the Fourth Geneva Convention isn't a get-out-of-jail-free card. It just sets rules, which the United States is not observing in these cases. It just sets rules on how these people are to be dealt with. But you're right. Military personnel are trained. If you're captured, try to get away, and it's proper conduct under the Third Geneva Convention. Yes?
Well, my question was, as far as I know, nobody else in this room has ever been in Guantanamo at the prison. Many of us may have been there in the service, but never in the prison. And you have seen top security other prisons in the United States. I was wondering, how does Guantanamo prison compare with top security prisons in the United States?
Nobody is getting out of Camp 5 or Camp 6 at Guantanamo. Camp 5 was built as a high-tech, state-of-the-art, secure facility. You would not believe what you have to go through just to get inside the facility. The guards you pass and the gates that are locked and all of that. Nobody's getting out of Camp 5. Camp 6 that's where my client was built as a communal facility, but they turned it into a solitary confinement facility, principally for the convenience of the jailers, because it's easier for them to control and manage the prisoners who were there. And take my word for it, nobody is getting out of there. They're as secure as the most, like Marion in Illinois. There's one I forget the name of in Colorado federal prison that nobody's getting out of. Period. End of discussion. Not going to happen.
But as far as their situation in that prison, not the security side of it, but are they just as well off as a prisoner in the top security prison in the United States?
About the same. These are new facilities. These are brand new. Camp 4 is fairly new. Camp 5 is brand new. Camp 6 is brand new. These are new facilities. So they're, as I say, they're modern, built state-of-the-art. Yes?
That has to do with my question. Given the state-of-the-art of our maximum security prisons or facilities and the control that we can have over the detainees, why is Congress so reluctant or fearful, if you will, to have them brought to these facilities here?
Because it's a political issue, and the Democrats in the United States Congress are weaklings. That's why.
Oh. All right.
Obviously, we thank him very, very much. So this has been a wonderful presentation, so thank you. I'm in the position of giving him a gift basket of Vermont things, but you have to remember he comes from Vermont. So in my choosing, I restricted these to Brattleboro area. I've never seen them again.